That's it. You gotta film me. I want to make a boomerang and send it to my page. Alright, I'll boomerang myself. You get already, okay?
Hi, everyone. Good to see that we are all here and that we're on time. Thank you all. I can see our beautiful faces. So I can see Favor. I can see Chelsea. I can see Onyinye, Ibuchim, Echeme. Thank you all for putting your videos on so that we get to see how you look. Thank you all. I hope that we've all had a lovely day today. Oyeni, okay, no, yes, Oyeni. So thank you all for joining us. This is the 5th week. Can we believe it? Even me, I can't believe it. It's already 5 weeks. How did time move so fast? So thank you all for joining us once more. Thank you for cooperating. Thank you for doing your work and all that. We are proud of you. we are all proud of you. And so my name is Juliana Imam. I'm not the moderator for today, but I haven't seen the moderator. So when I see the moderator, I'll just hand over. Before we go on, there are several things that I would like to just speak about, one of which is the private mentorship program. So for the private okay, so let me just go with Hussein. Okay, he has already taken that down. Okay, so for the private mentorship program, it is very, very important that we take note of it. So when we see the comments that mentees make every session, they talk about having a relationship with the mentors. Now, I want to encourage that the only way you can have a relationship with the mentors, personal relationship with the mentors, is if you have this one-on-one session with them. For example, I don't know your names like personally on this group, but if you have a 30-minute session with me, I would definitely know you, know your father's name, know your mother's name, know where you live and everything, because I've had like personal one-on-one time with you. The reason why I'm stressing this is so that at the end of the session, we don't have people saying that they did not interact with their mentors. The way you can interact with your mentors is to take advantage of this 30-minute one-on-one session. Next announcement is the party, end of year party. Hussein is doing all he can to ensure that this party is a huge success. And for the AI class, he encouraged them to fly from outside the country, from outside Abuja and all that. So I encourage everyone to try and set out Saturday, 10th of December for the get together. We have not seen ourselves physically, but it would be good for us to see ourselves physically. So who are we? Hussein, who are we? Please help me with the flyer for who we are. So Jiipcc Mentorship and Internship Program is a program that is organized by Jiipcc Intellectual Property and Mentorship. Okay, so he's moving to the part for registering for the program. So I want to encourage everyone, if you know anyone that would like to be mentored in intellectual property, artificial intelligence, the energy industry, fintech, health, tech and law, and patent drafting, please encourage them to sign up so that they can be among those that would participate for the next quarter. Please edit your names in the name section if what you have there is iPhone, Samsung, Zoom, Kola and everything. Please put your names, your full names. Thank you. So I'll be calling on the the moderator for today to continue. I can see that the person is around. Please, you can unmute and continue. I think I've
Thank
tried.
you very much, Ma. Thank you very much, Ma. You have. Thank you, everyone, for being here today. Once again, I want to welcome you all for joining today's meeting. We really appreciate you. I am Koinsola Adu, and I'm going to be the moderator for today's meeting. So, without wasting further time, Mrs. Juliana has already announced what we need to announce. So, I'm now going to be moving to the profile of the mentors. I'm going to be reading the mentors' profile. So, please, the screen for the mentors' profile. All right, so we're starting with our first mentor for today. Our first mentor for today is Linek Hage. I hope I pronounced this well. Lynn Carol Usibi. Am I right? Okay, so, and then she's going to be talking on registration, the topic intellectual property registration, infringement, and enforcement. So she is a senior lecturer at the University of Namibia School of Law, and she has 9 years experience in legal academia. She teaches the law of intellectual property and law of the league. She is holder of a Master's of Law obtained from the University of Stellenbosch in South Africa, and is currently pursuing a PhD with the area of intellectual property law at the University of Cape Town. Her research interests lie in intellectual property law, specifically, as well as commercial law and development. So please, thank you very much for being here. You all please join me to welcome her. Then our next mentor for today is the person of Mr. Folarinwa Aluko. So he is a legal practitioner and a partner in the law firm of Truman Rockwood Solicitors, where he provides advisory and consultancy services to companies and a wide range of creators, users, and startups. So Folarin is a director of the Intellectual Property Institute Nigeria, and he is the chairman board of trustees of the Intellectual Property Lawyers Association Nigeria. Folarin is a member board of trustee of the Sports Lawyers Association Nigeria, as well as a member of the board of trustee of the Nigerian Digital Chamber of Commerce. So Mr. Aloku is also a board member of the Songwriters Association Nigeria with a background in ICT, hardware, and digital forensics. So Folarin has led legal teams to champion consequential strategic impact public service litigation in the IP space since 2012. Folarin is a consulting mediator with commercial intermediaries and ADR firm based in Lagos and Abuja. So he is a thought leader in Nigeria's innovation, technology, intellectual property, and entertainment space. Thank you very much, sir, for being here today. So our next mentor for today is Ugochukwu Clementia, and she is a senior assistant registrar 1 at the Trademarks, Patents and Design Office, Abuja. Please help me welcome our mentors for today. So now we're going to be moving to the presentation that the mentees have today, and each group has 8 minutes to spend, so please try to speak adequately and don't exceed your minutes. So for now, we'll be welcoming group 1 for their presentation. Thank you. This is group 1 ready?
Yes, yes, we're ready.
Okay, thank you. Please carry on.
Okay. Good afternoon, everyone. My name is Ibuchim Uzoa, and I'm representing my group, and we'll be talking about intellectual property registration, national, regional, and international. Can you see my screen?
Yes, we can.
Okay, thank you. So we already know what copyright is from what we've been talking on for the past few weeks. Copyright is the exclusive right granted to any creator of the original work to represent, distribute, and perform his work. So work eligible for copyright protection includes literary, musical, artistic, and so on. For a work to be entitled to copyright protection, it must be original and must be expressed, like must be put in a medium of expression. Registration for copyright is not a protection prerequisite, as it exists automatically upon such work being original. However, the Nigerian Copyright Commission, NCC, has designed a voluntary scheme to enable authors to notify the commission of the creation of their works. So the requirement for copyright registration in Nigeria includes the particulars of the work being registered. There we have the author's name, address, and so on, which is provided on the slide. Then particulars of the author, the first name, last name, address, telephone number, email address. I'm sorry, I'll be a little bit fast because our time is short and then the slides are much. Okay, trademark is any word, name, symbol, design, or combination that is used to identify a particular manufacturer or seller. That's used to know that that particular goods is coming from a particular manufacturer or seller. The laws governing trademark in Nigeria are trademark regulation of 1919, as we can see. Requirement for trademark registration: words and logo to be trademarked, applicant's name, applicant's email. Nigeria can be registered in 45 different classes, which Ms. Amosa talked briefly with us last week. So moving on, the requirement for trademark registration in Nigeria is it can be done through an agent who is given the power of attorney, and the agent who is given the power of attorney does conduct an availability search, application, acknowledgement, acceptance, publication of the trademark, and then issue of registration. Patents. We know that patent is the exclusive right given to the owner of an invention to prevent others from selling or making use of it. So for such invention to be patentable, it must be novel, that it must be new, it must be gotten through an inventive activity, capable of industrial application, and then it must have constituted an improvement upon an already patented invention. So requirement for patent registration, the applicant's full name, address, and then if his address is outside Nigeria, an address for service, description of the relevant invention, claims, that's what are you claiming for this invention you are intending to protect, payment of prescribed fees, and then signed power of attorney, where is an agent who registers such work. Okay, moving on. Industrial designs. Industrial designs can be protected by registering it with the Nigerian Patent and Designs Registry. Okay, requirement for registration. A registration requires the applicant's full name and address for service. It's provided on the slides, so I'll be moving quickly. So trade secrets. Trade secrets are not really, they are not to be registered in Nigeria, but they are protected. They are protected in the form of legal and technological means, such as executing a confidentiality agreement or NDA. That's, take for example, when an employee comes into a company to work, he's usually signed, let's say, a non-disclosure agreement in that kind of instance. Okay, so regional registration of trademarks. We have ARIPO and we have the ORP. The ARIPO, the majority of its members are English speaking, and unlike the ORP, which is the Organisation Africana de la Propriété Intellectuelle. I hope I'm correct in the pronunciation. It's mainly, most member states, that's most people who belong to the ORP are former French colonies. So mainly the official communication from the office are issued in French, but it's possible to file in English. Okay, Nigeria is not a member state of either the ARIPO or the ORP regional office, but we'll be considering how patents and copyrights are being registered under the ARIPO. The ARIPO has 26 countries. The ARIPO, it is mandated to grant patents on behalf of the Harare Protocol, contracting states in accordance with the provisions of the protocol on patents, designs, and utility models. The protocol requires application to be made with any of the contracting states or directly at the ARIPO office. That is, you can either go to the ARIPO office or you can go individually as a country, or you can go individually in your country. A patent granted by ARIPO has the same effect as that granted under your national laws. So procedures include a completed ARIPO Form 3, that's a request form, description of the invention, one or more claims, one or more drawings, prescribed fees or written undertaking to lodge the fees, designation of at least one contracting state. Okay, trademarks. ARIPO is mandated to register marks, and the administration of such registered marks on behalf of the Boundary Protocol contracting states in accordance with the protection of Boundary Protocol. The first step in the registration of a trademark is to conduct a trademark search. So check the availability of that mark, and the next step is the application for registration. An application for trademark protection may be filed by a qualified or a legal person, either in person or through an authorized representative. Okay. Application for trademark. The applicant's name and address, corresponding class of goods or services, the names of color claims. We can see that on the slide. After filing the application, the next is the allocation of a filing date. And upon receipt of the application, the ARIPO office undertakes the examination of the application to determine a filing date. And then the next step is the formality examination. After the formality examination, the registration process, after the formality examination, then we have the substantive examination, which is conducted, then the publication of mark, which the application have been accepted on substantive examination. Then after 3 months After 3 months of publication, if there is no opposition, a certificate is thereby issued. Okay, industrial design, I'll just go straight to what must be contained for an application. A fully completed request for registration, that's Form 28, reproduction of the industrial design to be registered, designation of contracting state, and so on. It's almost similar with that of patent and trademark registration, but publication has to be on the ARIPO journal, and there must be an issuance of certificates. Copyright and related rights is provided for under the ARIPO mandate in 2002. So the administration of copyright and related rights in ARIPO member states is enabled by legislation put in place in the respective countries. This is through the national copyright offices and the CMOs, that's collective management organizations. Okay, so international. So we should know that internationally, there is no really like a certain recognized means of IP protection, but there are conventions that individual states can sign into or belong to. Okay, for patents, there are listed conventions and treaties that govern the registration and protection, but most widely used is the PCT and the Paris Convention. Okay, so the Paris Convention enables a member state to, if he files an international application, it can also be seen that such application is simultaneously filed in the 153 countries which belong to that certain treaty. The treaty is administered by the WIPO, and then you can either file through this means, that you can file with the Paris Convention, or you can directly file in your own country through a local attorney, provided you are complying with the requirements and restrictions set in your country. So for copyrights, the treaties or conventions are the Berne Convention and the TRIPS Agreement. The Berne Convention has 179 countries who are signatories, and it stipulates the rights of authors, their copyright duration, and so on. One main feature is that the Berne Convention enables foreign nationals to be given the same rights as domestic copyright holders. This enables foreign investment, and most especially, it helps to eradicate all unnecessary kind of formalities. Yes, and it aids the protection of literary and artistic works. Okay, trademark. The trademark, the first way to register a trademark internationally is by filing an application in the choosing country by hiring a local attorney or through the Madrid Protocol and Madrid Agreement. The Madrid Protocol allows for a standard application. The WIPO administers this protocol, and an application can be filed with the WIPO. Okay, the other international agreements that provide for the registration and protection of trademark include Benelux Office for Intellectual Property, the European Union Trademark, and so on. So in conclusion, registration of intellectual property works are very much important as it serves as a proof of ownership in certain cases. As we said, for copyright, it is not a prerequisite. Okay, therefore, creators should see it as a necessity to either register their works in their countries or the country in which they seek protection through the medium provided in that country, and provided that those countries are members or signatories to a particular convention which grants them protection in that country. Thank you for listening.
Thank you very much for your presentation. That was group 1. So now we need group 2 to please give their presentation. Is group 2 ready, please?
Yes, ma'am.
All right, please start.
Okay, so I want to share my screen. Sorry for the time wasting. I want to share my screen with you guys. Can you guys see my screen? Can you see my screen?
No, we
No, we
can't.
can't.
No,
see
not
your
yet.
screen.
Can you see it now?
Not yet.
Wow. Can any member of group 2 help me with screen sharing? I can see my screen, but you guys can't. Okay, I think you can start your presentation while someone in your group. Okay. Okay. My name is Librita Ukweze. I'll be presenting on behalf of Group 2. Our topic is IP infringement. Now we're going to be talking and we're going to be discussing some subtopics. We have physical and online infringement, and we have piracy and anti-counterfeit. Piracy and anti-counterfeit. Now, before we dive into the nitty-gritty of IP infringement, it is imperative that we understand what intellectual property entails. Now, intellectual property is an umbrella term for a set of intangible assets or assets that are not physical in nature. Now, attached to intellectual property assets and rights, attached to intellectual property assets and rights known as intellectual property rights, and these rights give owners the ability to bar others from recreating, mimicking, and exploiting their rights. Our topic is IP infringement. Now, IP infringement, simply put, is a violation or breach of intellectual property rights. And this violation occurs when a third party engages in the unauthorized use of assets. It occurs when a third party performs an act that is legally restricted to either the owner of the IP right or a person who has the owner's permission to exploit the right, which are the licensees. Now, effects of IP infringement. Here we're going to talk about the consequences of IP infringement. Number one, we have IP infringement hinders economic growth by discouraging investment. IP infringement is detrimental to the economy of a country and even a company at large, and even a company, as it hinders the company or country from attaining its full economic potential. Also, it diminishes financial benefits from creation. No, we're still on the other, yes. It diminishes financial benefits from creation. IP infringement robs entrepreneurs of profit and causes loss of revenue to a company and even a country as a whole. It also poses financial loss to consumers as well as health benefits. The next, please. Okay, yes, thank you. Then we have the legal effects of IP infringement. Now, IP, intellectual property infringement, tarnishes the reputation of the company or a business and could also lead to criminal charges and jail time. Here, Section 25 of the Cybercrime Prohibition Act 2015 provides for the punishment for anyone who is found guilty of IP infringement. It provides for a 5 million naira fine or 2 years imprisonment. Next slide, please. I apologize, we cannot explain everything because we have limited, no, please, next slide, thank you. We have limited time, so I apologize, we cannot explain everything. Yes, online IP request, please, online IP infringement. Yes, thank you. In the broadest sense, online IP infringement covers the sale of counterfeit products and services through the internet and a variety of its activities such as cyber squatting, phishing, and unsolicited email marketing. Next slide, please. Now, the next slide, yes, is the examples of online infringement of intellectual property rights. Some of it are, number one, sale of counterfeit products through direct sales. We have using similar trademarks in advertising or promotions, impersonating a brand owner's website or social media pages. We have downloading and selling of music, films, or movies online. Next slide, please. Yes, we have, no, please, next one. We have physical infringement of intellectual property. We cannot say everything because we only have 8 minutes. Physical infringement, it is conceived that intellectual property cannot be physically infringed, but IP in some instances can be accompanied with theft of an actual physical property or in conjunction with other civil wrongdoing. An example, when digital files containing product blueprints or technical drawings are accessed without authorization, then we say there is an infringement. Next slide, please. We move to another subhead. Yes, piracy. Thank you. Now, piracy is the unauthorized use, the copying, reproduction, or the distribution of intellectual property assets that have intellectual property rights protection. Examples of some assets that could be pirated are music, movies, we have softwares, work of art, etc. Next slide, please. Next slide. As piracy is one of the most common type of cybercrimes, the Cybercrime Prohibition and Prevention Act 2015, which is the principal act governing cybercrime in Nigeria, provides a punishment of 3 years imprisonment and a fine of 7 million naira to individuals or companies found guilty of piracy. Next slide, please. Here we have an intriguing case on piracy. This case is Disney Enterprise International versus Prime Housewares Limited. It's a 2014 case. In this case, Mumbai-based Prime Housewares Limited was manufacturing the characters of Disney, such as Mickey Mouse, Minnie Mouse, and Donald Duck. Disney filed a complaint in the case of trademark infringement with the primary argument that the trademark of the applicant is protected under the Indian law, but not the design. The court gave judgment in favor of Disney over the trademark infringement action for piracy. The court also instructed the Indian company to supply Disney with every pirated material so it can be destroyed. From this, it can be deduced that Mumbai-based Prime Housewares Limited really paid for infringing on Disney's rights. Now, the next is, please go to the next slide, please. Yes, anti-counterfeiting. Now, unlike counterfeiting, which refers to the illegal duplication, distribution, or sale of copyrighted products with the intent of imitating the copyrighted material, anti-counterfeiting refers to activities intended to prevent or reduce the existence of counterfeit products. Now, the next slide, please. Now, an interesting case of counterfeiting in L'Oréal SA versus eBay International AG. L'Oréal, a French multinational company, sued eBay and some other individuals who had sold several counterfeit items resembling brand names associated with it for trademark infringement. Now, it was argued that eBay was liable for using its trademark by displaying them on websites and on advertising and sponsored links provided by internet search engines like Google. Now, the court held, among other things, that a trademark proprietor is under EU's directive. The court held that, among other things, that a trademark proprietor under the EU directive is entitled to prevent the operator of an online market from advertising its goods without its consent. And the court also ruled that eBay may not be exempted from liability as it plays an active role in the sales of goods by optimizing the presentation of the offers and promoting them. So, which means eBay was liable under Article 14, Sub 1 of the European Union Directive 2000/31. Now, next slide, please. Next slide. Next slide. Done with this. Next slide, please. Yes. So, in conclusion, I say piracy, counterfeiting, and other types of IP infringement can be considered a violation of civil or criminal law, depending on the type of IP, the jurisdiction in which the offense occurred, and the type of violation. And intellectual property infringement causes financial losses, damages, and harm to both individuals, which are the users of these assets, and the producing companies. And in order to prevent these losses or reputation damages, companies should protect their intellectual property in a way that provides effective coverage. Thank you so much for listening.
Thank you very much. So now we've had group 1 speak and we've had group 2 speak. So now we're going to be calling our mentors to please give their comments about the group's presentation. So we're going to be starting with the first mentor, Mr. Polanwa.
It's group 3 and group 4, please.
There's still group 3 and 4. Sorry, apologies
Oh.
for so yes.
Okay, so group 3, please, your presentation.
Hello everyone. Please confirm if you can hear me.
Yes, we can hear you. We can hear you.
I'll be presenting on behalf of Group 3. I'm Ogonna Annette Ondiego. So we'll begin with an introduction. What is intellectual property? We all know what that is by now. We've been going on and on for weeks. And intellectual property is the creation or innovation of the mind. So it includes, even though it's not limited to copyrights, trademark, trade secrets, patents. So the intangible intellectual properties of our mind that's the owner of the intangible property right that an owner of intellectual property enjoys exclusively under the law. Next slide, please. So there are laws that regulate intellectual property, such as Trademark Act, Cybercrime Act, Copyright Act. I'll be fast due to lack of time. Please, next slide. So when do we say that an intellectual property right has been infringed? So it is infringed where a person or even a corporate body, that's a company, uses another person's intellectual property without without express authorization, be it copyright, be it trademark, be it whichever kind of right it is. So such person shall rely on the relevant laws to claim from the infringement. Physical enforcement of intellectual property rights. Upon the infringement of the intellectual property right of an owner, such owner can approach the court for redress. And this can easily be done by bringing an application or claim before the court, itemizing his intellectual property which has been violated. So the owner of in Nigeria, it's Federal High Court that have jurisdiction, and this jurisdiction was given to it under Section 251 sub 1F of the Constitution of the Federal Republic of Nigeria and Section 46 of the Copyright Act. Next slide. Okay, so anybody seeking for redress in court for infringement of copyright must establish that first he's the exclusive or joint owner, that's he can share that right with someone, but whichever way he has exclusive right to the intellectual property that has been infringed. He must also establish that the defendant who he's suing has violated his intellectual property right. Next slide. So, and other physical means of enforcing intellectual property is that, okay, the parties may decide to settle out of court due to the slowness and the length of traditional litigation. That alternative measures such as ADR, alternative dispute resolution, where the alleged IPR infringer and the owner would meet in a private setting and settle their matter. And after a written agreement, or which is a proof of the final decision that have been taken from the ADR, the agreement automatically become binding. Next slide, please. So the court can make any of these orders on the screen to indicate that to bring the person back to his previous position, like a restrictive position he was before the right was infringed, such as order for inspection, for seizure, order for injunction, for an award of damages, for accounting all the profits which the infringer had made the owner lose, order for delivery of. Next slide. So case study on IP physical enforcement. We have the Anton Pillar KG and Manufacturing Processes Limited. And this case is the locus classicals that established the Anton Pillar order we all hear of today. So in this case, the court made a civil order allowing the plaintiff to conduct a form of civil search and seizure, which is popularly known today as Anton Pillar order. There is also, this order can also be, is more like a motion which can also be granted, which can be sought ex parte without the permission or notice of the other party. So there is also the Hoffman, LaRouche and Co. and Secretary of State for Trade and Industry. So this case established the importance of bringing a claim for redress of one's violated intellectual property right. Next slide. When is physical enforcement feasible? So physical enforcement of intellectual property rights is feasible where the infringer can be easily identified or located within the territory. In other words, you know who this person is, or at least the person is identifiable. However, it's not same with online enforcement option where most times it is difficult to locate or identify the infringer because online is not a territory. Next slide, please. So enforcement using the online option. This is a major challenge when it comes to intellectual property infringement because internet is not a country that doesn't have a boundary, it doesn't have government ruler or rules of court or practice directions that can govern it. So it's difficult to identify this person or locate whoever that have infringed on somebody's right on the internet. And this it offers for anonymity, which has opened the door for infringement of intellectual property rights that are new in both nature and scale. Next slide. The TRIPS Agreement. So the TRIPS Agreement is one of the global and international treaties that regulates enforcement of intellectual property rights internationally. So it was signed and it came into force in 1994. Article 47 of these TRIPS agreements provides for right to information, which must be an information. Article 47 of the TRIPS agreement provides for right to information, which must be an information that must be provided by the infringer. And this further makes it difficult to locate or identify the infringer. The internet poses very specific obstacles to effective enforcement, which are not addressed in the TRIPS agreement or in any other global treaty. Next slide. Issue of where to sue. So online intellectual property rights infringement may warrant cross-territorial action, and the arising questions will be, first, what is the jurisdictional competence? That is, what court has jurisdiction to sue this, to handle this matter, this online matter, and what is the applicable law? And thirdly, how to carry out an enforcement of judgments if you do get it in another country. Next slide. Okay, final point to note. The WIPO joint recommendation concerning provisions on the protection of marks and other industrial property rights and signs on the internet proposes a possible way to alleviate the concerns regarding trademarks conflicting with existing rights in other forums. Next slide. So this provision addresses three major questions. And the first one is, when can use of sign on the internet be considered to have taken place in a particular country? The second question it addresses is, can those who own conflicting rights with identical or similar signs make use of these signs online? If so, under what circumstances? And thirdly, it addresses how can courts take account of the territorial basis of trademark rights when determining remedies. Next slide. A case study of online infringement of intellectual property rights is the Hotel Maritime case. So in this case, a hotel owner in Denmark had a registered trademark under Hotel Maritime, that's in his territory, his country, Denmark, and opened a page on the internet. They're using the domain name www.hotelmaritime.dk. Meanwhile, another company in Germany that has over 40 hotels in that same Germany under the name Hotel Maritime. It's the same thing with Maritime, just doesn't have that E. I had registered this trademark. Just a second. Okay, I has registered this trademark in his country, Germany. So a dispute now came, of course, registered it online too. So a dispute now became who has the online territory. And it was decided by the Federal Supreme Court of Germany in 2004. The Danish hotel owner was infringing the sign on the hotel webpage. Next slide. So the court held that in line with the element of the WIPO joint recommendation, reason that not each and every use of the sign on the internet should be treated as taking place in a given country, even if it was accessible to internet users based there. Only where the use of the trademark had a commercial effect in a particular country could it be treated as having taken place in that country, and thus be possibly relevant. I can't see my screen again. Am I the only one that can't see the screen?
No, I can't see your screen too.
No, you're not.
Okay, just give me a second. Let me open it. Let me share it myself. Okay. All right. So I stopped it. Okay. Only where the use of a trademark, I was only trying to establish that this online, the question of territoriality in online use of a trademark, that it only applies where it has a commercial effect. So that on this basis, the Danish defendants arguing that the hotel services he offered did not have sufficient commercial effect in the said country, that's in Germany. In other words, he can't use his trademark and restrain the rest of the world from using that trademark unless it has commercial effects in that other country. Next slide. Okay, conclusion. Physical enforcement of intellectual property rights is less cumbersome. Why online enforcement of intellectual property rights is almost unrealistic, and most times very hard to attain. That's why online infringement happens almost every minute, but very few take it up to enforce their violated rights. So this is a recommendation that WIPO and other intellectual property trade organizations should incorporate treaties that match with present day internet. In other words, someone trying to enforce online infringement should be able to have laid down procedures to go through that can guide both parties, that he can abide by and get his relief or whatever is seeking the court to do for him. I think that is the end of my presentation. Thank you very much.
Thank you very much, Group 3, for your presentation. So now we're going to welcome Group 4. Please, Group 4, your presentation.
Good afternoon. Can you see my screen? Can everyone see my screen? Good afternoon.
Yeah, good afternoon. I can see your screen.
Yes, we can.
Can everyone see my screen?
Yes, we can.
Okay, good evening. I'll be presenting on behalf of Group 4, and we'll be talking about arbitration of intellectual property disputes. According to WIPO, which is the World Intellectual Property Organization, arbitration is a procedure or a means by which disputes that are submitted by agreement of parties, to arbitrators, it could be one arbitrator, it could be two, and by that submission of that case or the matter, the arbitrator or arbitrators make a binding decision, and everyone agrees that this is the way to go. So in choosing arbitration, the parties themselves will have to decide that this is the way we want to go. We want to go the route of arbitration. A few of the characteristics are that arbitration is consensual, so two parties or all of the parties must agree. The parties have the decision or the liberty to choose the arbitrator that they want to mediate in their affairs. Arbitrators can be chosen based on expertise. A great advantage of arbitration is that it is speedier in resolving issues rather than going through the route of litigation. Arbitrators are generally neutral. They also ensure confidentiality of the procedure, and there's a lot of flexibility. Lastly, it says that internationally, awards are enforceable. So we'll just quickly look at the nature of IP rights and IP disputes. According to Article 2.8 of the Convention establishing the World Intellectual Property Organization of 14 July 1967, as amended, it defines intellectual property to include rights related to literary, artistic, and scientific works, inventions in all fields of human endeavor, scientific discoveries, trademarks, service marks, and commercial names and designations, amongst others. Okay, still speaking on the nature of intellectual property rights, disputes concerning intellectual property are traditionally mainly dealt with before national courts. However, we've seen that in recent times, there's been a shift towards arbitration, and these national courts have agreed that, sometimes the appropriate way to go will be through arbitration. So to meet the particular needs in IP and technology disputes, the WIPO even went ahead to establish Arbitration and Mediation Center as a means of dealing with intellectual property disputes. So arbitration can, two issues will be considered when an arbitration case is brought before, let's say, either the WIPO or other arbitrators. Number one is an arbitrary clause in place. So when people are perhaps entering into contracts or trying to do their trademarks and all of that, do they have in place an arbitrary clause? Because it is a core element for many IP disputes. So the IP owner's rights to prevent others from using its IP, seize, or disease claim. As a matter of fact, usually there is no contract in place between the rival parties. And even if there is, for instance, license agreements, technological agreements, okay, all this is trying to say is that there must be an arbitrary clause in place for the either the arbitrators to be able to sit over that issue. That's one of the things they'll be checking or looking out for. The second thing they'll be looking out for is the matter, is the dispute arbitrable? So the existence or validity of ownership or scope of certain IP rights are least preliminary. So there are some cases that we brought before the courts that are not arbitrable. So the courts will be looking to see that this matter or this dispute is arbitrable. So arbitrability of intellectual properties, we're continuing. Since IP rights are generally conferred by the government of a particular country,
Each country has rules and regulations deciding the arbitrability of IP disputes. So in a few cases, there has been the practice that has not been followed because there are intellectual property rights that's against the whole realm. So for example, if you have a case against the whole world, that kind of case is not arbitrable. It must be against another party, another company, another person. Those kind of cases are arbitrable. So in current times, many countries have been adopting measures to ensure that issues related to intellectual property are made arbitrable, just like every other kind of dispute. So let's quickly look at applicable laws. Challenges to the arbitrability of a particular dispute can be presented to either a national court or arbitral tribunal. So both the courts and the arbitral tribunals will take into consideration the underlying arbitration agreement, which will most likely contain a choice of law. When the choice of law is not provided in the agreement, a court generally will apply its own country's laws and public policy considerations, while an arbitral tribunal would typically apply either the law of the seat of the arbitration or the law of the jurisdiction in which the arbitral award is likely to be enforced. A few of the factors that will affect the arbitrability of disputes or otherwise are public policy, third party and their rights, exclusive authority of the state. Due to time, I will not get into any of those details. So in Nigeria, let's look at the arbitration of intellectual property disputes in Nigeria. So we've said here that in Nigeria, there are no express statutory provisions to settling disputes. However, there are references made in certain laws, which we would like to cite here. For example, contractual alternative dispute resolution provisions. These are common in franchising, licensing, or sponsorship agreements. Such agreements will provide for an ADR mechanism for resolving the disputes arising for the contract. Secondly, we will have the regulator empowered by the statute to refer to people exploring ADR. So we have Section 13(3) of the Trademarks Act, making that provision and referring people to ADR mechanisms when there's a dispute. Also, we have court-ordered ADR. For example, Section 1 of the Federal High Court Act and Section 24 of the High Court of Lagos 2003 provides that the courts may promote reconciliation and encourage and facilitate settlements. So when they are saying this, ADR or other alternative dispute resolutions, which obviously includes arbitration. The next law is the Uniform Domain Name Dispute Resolution Policy. And this is a process established by the Internet Corporation for assigned names and numbers for the resolution of disputes regarding the registration of Internet domain names. And ICANN and WIPO developed the UNDRP and its rules. Some of the advantages of keying into the Uniform Domain Name Dispute Resolution Policy is that the mechanism sees to rapid and cheap and reasonable resolution of disputes arising from domain name conflicts by avoiding the traditional court system and allowing cases to be brought to a set of boys that determine domain name disputes. One of the case studies we'll be looking at as facilitated by WIPO, which is the World Intellectual Property Organization, is that a European company had registered a trademark for luxury goods in different countries. Meanwhile, an Asian manufacturer started to sell fashion products under a similar registered trademark. The Asian company now filed a case and administrative cancellation proceedings in 2 European countries, alleging non-use by the European country of its trademark. After the courts sat and they went to appeal, the parties settled their dispute by concluding a trademark coexistence agreement, which included a WIPO expedited arbitration clause. Now, when the European company used its trademark in a trade fair, the Asian company initiated WIPO expedited arbitration proceedings, claiming infringement of the coexistence agreement. Now, following consultations between the parties and WIPO Center, a European trademark specialist was appointed as sole arbitrator. And after 2 rounds of pleadings, the arbitrator conducted a one-day hearing in Munich, Germany, and issued an award 6 months after the commencement of the proceedings. And they found in favor of the Asian company. Let me just quickly go to the second case study that we have. This one is a case of patent infringement, and it was also submitted to WIPO. So following litigation in several jurisdictions, 2 American companies agreed to submit to WIPO arbitration a dispute related to the alleged infringement of a European patent concerning consumer goods. The submission agreement provided that the national patent law of a particular European country would apply and that the patent litigation timelines of that country should be followed. The 3-member tribunal was asked to decide whether the manufacture and sale of certain products infringe the patent. The submission agreement and compliance with the procedural timetable in the subsequent arbitration process reflected the parties' mutual interest to resolve the dispute in time and cost-efficient manner. The parties accepted the center's recommendation to appoint 3 arbitrators with substantial expertise in arbitration and in the relevant national patent law. Further to the exchange of written submissions, the arbitral tribunal held a one-day hearing in Geneva for further statements and for the examination of expert witnesses. Then, in accordance with the time scheduled agreed to the parties, the final award was rendered within 5 months of the commencement of the arbitration. Just to conclude, we've seen that the WIPO has administered 900 cases from 2012 till date, which shows that a lot of cases are going to arbitration, especially as regards intellectual property. And we also recommend that when drafting IP agreements, parties should consider including arbitration clause as a valid alternative dispute resolution litigation. Thank you very much.
All right, so thank you very much. So now we've had our amazing mentees speak, and now we're going to be moving to the mentors. So each mentor, please, has 10 minutes to give their opinion on the presentation of the mentees. So we'll be starting with Mr. Folarinwa Aluko. Thank you.
Good afternoon or good evening, everyone. I trust we're having a pleasant day. I should commend all the presenters from, I didn't catch group 1, but group 2, group 3, and group 4, for putting together in such a, in such a short and punchy format, topics that are quite wieldy and wide. So I would say well done. And thank you. It's been a very interesting, it's fun to learn and to relearn. I would say that it's a good idea. I know that many of the concepts in intellectual property can be vague to a lot of people. And they can also be vague to to people who perhaps maybe have not had the opportunity of working in that area or in the fields that those rights protect. For example, when you're talking about questions of novelty, or even let's talk about dispute resolution before. Talking about dispute resolution, it means different things to different people. Dispute resolution to the owner of a domain name, it may involve a different process from when you are talking about dispute resolution with a patentee, patent holder, or with the owner of a work of art, for example, of a sculpture. So because IP, the subject matter of intellectual property is very broad and very wide, wider than the Atlantic Ocean. I can understand that as a factor, that you would have had to deal with in putting up representations. That being said, it does help to contextualize the conversation a lot of the time. you'll find out that in as much as the subject matter area is wide, it does help to narrow down, on specific areas. Say, okay, for example, let's look at this area. And I like the fact that we talked about for dispute resolution, for example, there was a conversation. The conversation went to some of the various ADR mechanisms. I'm not sure I heard anything about the what's it called now? The Copyright Commission's ADR process, or the Intellectual Property Institute mediation and ADR process as well. But it's good that for ADR for Group 4, it's good that we're having conversations around the subject matter, the option of mediating and of settling disputes by alternative dispute resolution. I know you mentioned arbitration. I think there are concerns about, I think there are some jurisprudential issues around arbitration and intellectual property, whether certain IP rights are arbitrable or can be subjected to arbitration, considering the fact that, they sometimes touch or border on issues of fundamental rights. That's talking about arbitration now, or even mediation. What happens when I was, as an aside, I was in a forum some months ago, where somebody, a very popular arbitrator, was saying that his own business is to arbitrate, based on the issues before him. That is actually the work of the lawyers to the parties to define whether the subject matter is arbitrable or not. It's up to the parties to determine whether the subject matter is arbitrable. And I know that it was highlighted in Group 4's presentation, but it would be good to expand a little more on some of these conversations that not many people are having at the moment. I also like the fact that you talked about, that's Group 4 now, talking about arbitrability. I seem to be interested in that. I like the fact that we went in. We talked a little bit about some of these disputes, but it would be good to have a practical scenario, or a scenario-based conversation. I think that would drive home the point much better, much faster. With regards to Group 3's presentation, which is about, is it Group 2 dealt with national, regional, and international registration. And I also agree, there's also a lot of confusion around international registration. What does it mean? Whether you're talking about trademarks, patents, industrial design, there's a lot of confusion in the public domain. You find clients who come and say, "Oh, I want to register a worldwide patent, international patent," and the assumption is that, it means that I will not have to register, and then I'll just register one, and I don't have to go to any other country to register again. Of course, that could not be further from the truth, to the extent that IP rights are based on, they are created by the municipal laws of the various states. Yes, so there's that. And I should also mention, I'm trying to remember who talked about this WTO TRIPS. Someone talked about TRIPS and called TRIPS an agreement. TRIPS is not an agreement. There's also some confusion around that. I think TRIPS is a standard form, like a minimum set of rules, a minimum set of guidelines, not an agreement. It's not a treaty. It's not supposed to be an international legislation, what you may call international law. I see people citing the provisions of TRIPS as what do you call it, as authorities, even in court, in cases in court and the trademark tribunal. Well, I stand corrected anyway, but from my little understanding or knowledge of the WTO, TRIPS isn't an agreement. It's not an agreement that can be acceded to or domesticated. It's not that sort of document. It's a minimum set of rules and regulations, minimum set of laws. It's a minimum set of laws, a minimum set of rules and regulations. So again, I think the essence of this interaction, of this program, is to ventilate some of the, to ventilate some of these issues, bring IP issues into the front burner of general everyday conversation. So to that end, I should say well done to all the mentees.
All right, I think Mr. Folarinwa is temporarily unavailable. So we'll be calling on Mrs. Juliana to please give our comments on the presentation of the mentees. Thank you.
Okay. Hi, everyone. So the two mentors, both of them have emergency meetings, so they might still join us before the end of the meeting. But based on the presentations that we had, so I just want to touch it from a practical perspective, since we are all young and we're starting our careers. So I want to say, first of all, that we should not be scared of these things. So when people reach out to you, maybe clients and all that, and saying, oh, they want to copyright, they want to trademark, they want to do all that, don't say that you cannot do it. You can do it. You might not know that you can do it, but you can do it. So, and a secret to this is that many people that you see online that do a lot of trademark advice, copyright advice, they have not actually registered an actual trademark, copyright, and all that, but they are faking it until a real person comes to reach out to them that, okay, yes, I want to copyright, yes, I want to patent, and then they reach out to someone that is working there to explain to them how to go about it. That's how most people started here. So what I would like to advise is try and read about the steps to registering copyright, registering patents and all that. It will help you when it's time, so that at least you have an idea and then you already know the steps and everything, so that once it's time, you can actually do it for your clients. Because while we are doing this thing is for you to be able to use it for your clients, right? You're not just doing it for head knowledge and all that. So if you want to do a registration for copyright, you can do that online. That's if you're in Nigeria, and in most countries, you can also do it online. For you to do a trademark, patent, and design registration, you can also do it online, but you would still need to have an insider because they have issues with their system. For the regional registration, for I think OAP, once you do a single registration, it covers the French-speaking countries. But for ARIPO, which Nigeria is not a signatory to, registering with them does not mean that you have automatically registered with all the African countries. You still have to signify the countries that you want to register with. And then for the international route, when you go through WIPO, it doesn't mean that you have done the registration in all the countries. What it means is that you have a single payment, you have a single filing and all that. But when you get the filing, then you tick the countries that you're interested in, or you tick the regions that you're interested in. So you can tick EU region, you can tick like all those mid region and the rest. Then you can tick particular countries that you are interested in. So based on the countries that you tick, it will then tell you how much you're paying and all that. But even after you're done with all that, you would still have to move to the localized state, but you first have to register in your home country. So if your country is not a signatory to maybe the PCT, the Madrid and all those things, if you have a client that wants to register in those that wants to use that method, it might be advisable for you to do your first initial registration in a country that is a signatory to that agreement, so that you can make use of it. Because I don't think Nigeria is one. So even if you have done your first registration here in Nigeria, you might not be able to take advantage of PCT and Madrid and the rest. And then for the infringement, for intellectual property, you are the police of your case. You are the police of your work, or you're the police of your creativity, your invention, etc. What this means is that when there's a criminal case like robbery, rape, and the rest, it's like you versus the state, right? That's like the criminal versus the state. But for an intellectual property case, you are the one that would actually say this particular person is infringing on my work. So you're the one to actually bring the case up. So if you have a client, you should advise your client to put their eyes out to watch if people are infringing on their case. So for example, when I was doing my master's, there was a trademark that I registered. Later on, somebody came into the country and wanted to use that trademark for a particular program. Someone saw it and told me, then I had to write to them. So you have to advise your clients that for an intellectual property case, you are the police to your own case. But for counterfeiting, some of these bodies like the Copyright Commission, customs, police, and the rest, once in a while, they might go around like to stores and all those places, check by the borders to check for fake products and the rest. But generally, for intellectual property cases, you're the police of your case. And then for enforcement, yes, you are the watchdog. Thank you. So for the enforcement, physical enforcement, of course, you have to go to court physically for them to give you like a ruling and all that, for you to be able to enforce it. But if it's online, you can go through like a cease and desist. So you can write to them online and say, come, you're infringing on my work, bring it down. Or you can write to the body that is hosting that particular work and ask them to bring it down. Or if it's on YouTube, you can write to them to bring it down. So there are several cases where this have been done. For example, I think 2 or 3 years ago, I had someone that was writing for a sports blog. And by the time they were not paying him what he wanted, so he told them to stop posting his work. But even when he terminated it, they were still posting his work. So what he did was to write to the body that was hosting the website to take down the write-up that had his name on it and all that. So you can write for them to take it down. Then for musical works, there's a way you can register your musical works that would have like a fingerprint on it. And so if anyone is infringing on your work, you should be able to bring it down or still benefits from it financially, even though they are the ones that uploaded it. That's the reason why you see that if you should open a YouTube video, maybe Lasisi or any of those comedians or even dancers, they might dance to songs that are not their songs. But the thing is, by the time they are done, YouTube, because of the fingerprint method, they would know whose songs have been used and they would monetize it and still channel the payments back to them. So generally, you have to put strategies in place for you to be able to know when your work is infringed upon, and then you have to follow it up yourself. And then for arbitration, I think that was a good presentation already, so no need to flog on it. I just want to commend all the groups. I think you have done very well. Thank you very much.
Thank you very much.
All right.
Ma.
Thank you very much, Ma, for that amazing contribution. This was indeed very enlightening. So now it's time for us to take pictures. So I encourage every mentor and mentee present to please put on your cameras and then please take screenshots and post it on LinkedIn. Thank your mentors and please tag your mentors and also tag JIIPC. Thank you. I hope we've done that. Thank you very much. So now we're going to be moving to our question and answer segment. And the mentees have different questions to ask the mentors. So I'm going to start with the first question available, and I'm going to be directing this firstly to Mr. Folarinwa Aluku. So the first question present here is, how is infringement traced in the metaverse? How is infringement traced in the metaverse? So Mr. Folarinwa Aluku, please.
I'm not sure. I found out that, hello, I found out
Yes,
that
sir.
I was, yes, my apologies. I found out that seems like my internet tripped up, but I'm back anyway. So how does infringement work in the metaverse? I guess it's almost the same way that it works in real life, I guess. In the I'm someone who has followed cyberspace, and I think cyberspace operates just like real life. People can own assets in the metaverse, in cyberspace. Domain names at one time were thought to be the new real estate. And to some degree, there's some similarity of. So I think that people can own property, assets, in the metaverse, including brands. So you can have a brand that exists in the metaverse in cyberspace, in the same way as you have a brand that would exist in real life. The question, however, would now center around what laws would apply in the metaverse. And I think there are already a lot of working groups that have been set up to come up with, that are looking at answering that question as to, okay, should the laws that govern, let's use this phrase, the metaverse, or should the laws that govern this online community, should it be set by the creators of the framework of the platform, or should there be some sort of community arrangement or community guidelines that are agreed on by everyone democratically? But I think online communities will grow in the same way that physical communities grow. And I do see a situation where as virtual reality becomes, more part of our day-to-day lives, I do see a situation where people can actually buy assets, trade in assets, set up, and also participate in democratically structured societies that are entirely virtual. So with the question of how infringement can work in the metaverse, it would be almost as infringement work in real life. In a virtual community, somebody uses an asset, uses a brand, or that's if you're talking about trademark infringement. If you're talking about, of course, patent infringement might be a little tricky because you would have to be able to create inventions and perhaps maybe those inventions will enjoy some sort of protection. Because again, the question as to what laws would apply. You should remember that IP rights are tethered to municipal law or local law. So for the right to exist, there must be a law that a legislature somewhere. I think at the moment, what you generally find is that in the terms of use or the terms of service or the terms and conditions, you find a jurisdiction clause that will tether the activities on that platform to a particular real location or real jurisdiction. I think that's what we tend to find. But can infringement occur in the metaverse? In my opinion, the answer is yes. But then you have to have a right in order to have infringement. And that right must be created by law, and that particular virtual community, online community, or that part of the metaverse, must be situated or either tethered to somewhere, or it must have its own rules that create the sort of property laws, that infringement can now ensue or accrue from. I hope that makes some sense. Hello?
Yes, sir. Yes, sir.
Okay. Yes, so that's my response to
All right.
question.
Thank you very much, sir, for that amazing contribution. So, Mrs. Juliana, do you have a contribution, ma'am?
I'll just say that the week that is coming, not this week, the week after this week, we'll be treating AI, metaverse, blockchain, and all those things. So if you have any of these kind of questions, you can keep it for some metaverse experts that will be coming then. Thank you.
All right, thank you very much, Ma. So now we're moving to our second question for the day. And then the second question that we have here is, since Article 47 of TRIPS gives an infringer the sole right to provide information about him or herself, how can this be reconciled where the infringer refuses to disclose the real information about himself? So I'm going to read it again one more time. Since Article 47 of TRIPS gives an infringer the sole right to provide information about him or herself, how can this be reconciled where the infringer refuses to disclose the real information about himself? So, Mr. Folari Aluku, please answer for us. Thank you.
Hello, can you hear me?
Yes, sir.
Hello. Okay. I am not very sure that, unfortunately, the article in question, I don't have the provisions of TRIPS in front of me, but I was saying earlier that TRIPS is not an it's an agreement in the sense that what's it called? It's not an agreement as per international law in the sense that, I don't know, that it's a document that should be domesticated, or like it's a document that should be, in my opinion, that should be cited in court. It provides a set of minimum rules and guidelines that IP laws local or domestic IP laws should adhere to. Having said that, this particular Article 47, I think, was paraphrased. I really would need more information about the context. However, I should say that talking about, I am not sure that, it says, the question says, the article gives an infringer the sole right to provide information about him or herself. I'm not sure. In most cases, once infringement is identified, let me speak about infringement generally. Once infringement is identified, or infringing activity is identified, the next question would be to find out who the infringer is. And I know that most countries have laws that allow people, laws by which you can find out who is carrying on what. And in terms of identity, I think identity issues arise where maybe somebody is hiding behind the veil of a corporate entity, and then just like in the Apple iPad trademark case, where you had Apple thought there was a group of companies, and Apple dealt with the wrong company, a company that was a part of the group, but that did not own the actual trademark for iPad. But that speaks to trademark subject matter. So I think talking about providing, disclosing real infringement or real information, I think most countries have laws that allow or that require that the corporate bill, where an infringer is hiding behind the corporate bill, because that's one area to be specific, where I see, this issue of an infringer hiding behind something. That's one concrete example. So in those types of situations, I think most countries have laws that allow for the corporate veil to be lifted. I know that in Nigeria, there are so many provisions that allow directors to be held liable, for acts that are done in the name on behalf of the company. And in the same vein too, our Companies and Allied Matters Act also provides for situations where a company can ratify ultra-virus, that's acts done outside the scope of the authority of the directors. So I would say, I think that would be my answer to that question. I just wish I had a copy of TRIPS right in front of me. But perhaps if we can, maybe we can talk later, and we can talk later about that. Again, like I said, it's important that we should know that I think that TRIPS is more of a, I don't think it creates substantive rules per se, in the sense that what's it called? There are provisions that should be cited in the court. I think the rules in TRIPS are minimum standards that countries or domestic law should adhere to. While we're talking, I've actually opened up Article 47. Someone has brought it to me. And I think what it deals with, Article 47 deals with just as I was saying, the right of persons to, I'll read it out. Members may provide that the judicial authorities shall have the authority, unless this would be out of proportion to the seriousness of the infringement, to order the infringer to inform the right holder of the identity of third persons involved in the production and distribution of the infringing goods or services and of the channels of distribution. So again, this is, like I said, the corporate form can be one way in which somebody may be hiding behind, another format, or may hide behind a third party to carry on infringing activity. And what Article 47 is saying is that member states should empower their judicial authorities. These also sometimes include the enforcement authorities to order infringers to also provide details or information about third parties. So an infringer, for example, maybe let's go back to the days of compact discs. So an infringer under Copyright Act, the machines that were used to make infringing copies are also subject to the jurisdiction of the court. They can be seized, they can be destroyed, and so on and so forth. Either they can be seized by an unpopular order for search and seizure. They can also be destroyed as a final order, or by way of an order for conversion. So, but then the infringer may not be the owner of the machines used to create these infringing copies. And so in this context, you might see the infringer, but then the infringer has 10,000 copies of a particular CD. But then you know that this infringer doesn't have CD making equipment. In that situation, the court or the member laws should empower the court to order the infringer to disclose the information of people who, so the person with the CD plates that provided that service should also be disclosed, and along with their channels of distribution as well. So I think that's what Article 47 says. It's a right to information, and it's a right to information for the right holder. It doesn't give the infringer the right to disclose it. It requires that the judicial authority should be empowered to order infringers to provide information of the identity of third parties who were party to the infringement, to the production and distribution of the infringing goods or services. I hope that makes some sense.
All right, sir.
Hello?
Thank you very much. Yes, sir. Thank you very much, sir. So now the next question that we have here is, won't it be right to say that online enforcement is really hard to carry out? Please, we need more information about online enforcement. So I'll read the question one more time. Won't it be right to say that online enforcement is really hard to carry out? Please, we need more information about online enforcement. So please, sir, lead us answer. Thank you.
Well, I would say, would it be right to say, that sounds like a cross-examination question. And I hope I'm not being cross-examined. I would say the answer, it would be right to say and it would not be right to say. In the sense that, everything, I have the fortunate pleasure of, at least of seeing the internet develop, over the years. And I've also had the pleasure of, or the privilege of having access to a computer since the late 80s. And I know, and I also have a computer engineering background as well. And I can tell you that these things are a little funny to lawyers, but nothing exists everything that exists in the cloud is actually tethered somewhere. It's tethered to the ground somewhere. What we call the cloud, I remember about 15 years ago, I also tried to, there was this DocuWare software that allowed you to put documents on a optic recognition software, but it also had this sharing function. So you could scan files in an office and then put them on a server, and that server will be accessible to everybody within the office. And you have multiple levels of access to the files and so on and so forth. But the idea is that everything that exists in the cloud or online is actually tethered, is a file on a server somewhere. And those servers, because the file is somewhere in this world, in the real world, because it's somewhere in the real world, the location of where that server, wherever that server is located, is also governed by laws. And so to that end, that's why for those who have followed, I've followed streaming from the days of was it Napster? From the days of file sharing, Napster to LimeWire, to torrents. I've kind of followed the evolution of that technology, and we find that it's easy to shut down this. This is not easy. These companies can be shut down. It could be expensive because sometimes the servers that you need to shut down are located in a jurisdiction, outside your continent or outside your country, and it could be problematic, getting the resources to mobilize a legal team and mobilize law enforcement, to get the necessary court orders to shut down these servers. But then everything online is domesticated in a server somewhere on this earth, and those locations, and you find, and I think to a large extent, there are more places, many more laws are actually, many more countries are passing laws that are more stringent on infringement generally, and that recognize or provide what you may call bilateral recognition, which essentially is a system that says, okay, if you if your country recognizes IP, certain types of IP rights, maybe copyright, trademark, patent, and industrial designs, and so on. If these two countries agree that we will recognize IP rights for the purpose, creating IP, intellectual property created in both our countries, for the purpose of stopping infringement and enforcing, certain rights, enforcing certain types of these rights. So maybe rights to reproduction, distribution, those types of infringement on those rights. But so I would say that infringing, fighting infringement online can be difficult because the first step is probably finding out where the infringer is located. But once that question is answered, everything now boils down to a question of cost and convenience. And then, of course, because of the multilateral nature of intellectual property, that means intellectual property relies on the laws of the various localities. Because that multilateral nature makes it a little difficult to track, because you need to understand the laws of the place where what you may call in contract law, it would be the lex loci celebration is, the place where the thing occurred or the contract was consummated, where the infringement occurred. If you find out where the infringement occurred, you need to know what the laws are to know whether you can actually enforce those laws, whether it will be cost efficient, it will be too costly, whether it will be cost efficient, and all that. So that's why my answer will be, is it correct to say that it is difficult? The answer will be a yes and a no, because it will depend on the location. But the first thing is always, everything that happens online, is tethered to a real location. And I should also mention that if the infringement happens on a platform, most platforms already in their community rules, their terms and conditions, have rules about intellectual property infringement. So YouTube, for example, very strong takedown rules. Same thing with Facebook, same thing with Instagram, TikTok, Twitter, and so on and so forth. So once there's infringement, if the infringement is done on the platform, there are rules and regulations that govern. The various platforms have their own rules that also allow for appeals, and for a review of the takedown regulations or takedown actions. So that's my take on online enforcement. Then, assuming it's on a server, let's say a website, an independently owned website, is hosting content that is infringing, then you have to find out, where that the server of that website is located. One of the ways you can do that is to conduct a who is search. Who is, and GoDaddy and a lot of all these other domain registrars provide this function. You do a who is search, but then sometimes also you can pay. Not sometimes, people can pay to hide their domain information, the registration information. But there are tools that will provide, at least to provide you with the location of the server, or location of the company, or location of the individuals. Because unless they're faceless, it's when they're faceless that you may not have to go much deeper. But most times there are always clues and cues as to who the human beings behind that, what's it called, thing. I remember some years ago, revenge porn was very common. People would get text messages telling them that there was a compromising video online, and there will be a link to a blog that would host, some pictures or something, and the person will say, "Oh, you have to pay me, or I'll publish it." And just a simple report to Blogspot, to the host of that platform will do the trick. The good thing in Nigeria is that the NIRA, is doing a lot of work in terms of internet governance. And so they also handle for the .ng extensions or the .ng domain tier. they handle, issues that have to do with that, with takedowns or suspensions and so on and so forth. I hope that answers the question.
Yes, sir. Thank you very much for that. Thank you. Now we're going to be moving to our next question. And our next question is, who bears liability for artificial intelligence machine used for online dispute resolution? I'm going to read it again. Who bears liability for an artificial intelligence machine used for online dispute resolution? So, sir, please answer that. Thank you.
That's an interesting question. I think I would reframe that question because the purpose of online dispute resolution is to actually determine liability or to resolve liability. So I don't think the question of would you hold an ODR platform liable? Parties go to ODR to resolve disputes. So I'm not sure if the question is framed properly. But let me reframe it. Let me try. Maybe the person is asking that how do you determine who is liable when an ODR platform is manned by artificial intelligence, or an artificial intelligence, or by a bot, for example? And I will say, how does, and I guess everything will have to come down to the coding. Everything will have to come down to the coding. Because if the question is, what does the AI, how does the AI determine liability? I guess there are many ways. The coding will have its internal framework, I guess. But I can speak to ODR because I've done some work in the ODR space, and I also provide mediation services with the IP Institute, and I've participated in several conciliation and mediation sessions. I can say that a platform, for example, like AliExpress, for example, is not IP, infringement. It's not dispute resolution per se. But one of the ways that they resolve disputes between, that's B2C now, buyers to customers, or business to customers rather, is by asking the customer to provide evidence of either a failed transaction or a defective product, or whatever complaints, the customer may have. And there are like a series of steps that the customer will take, or that, the customer is supposed to provide. And once the customer provides or follows those steps, then the business is then expected to respond. And then after that, everything is weighed and a decision is taken. And these sites tend to favor the customer by default, because that's one of the ways that you can build trust in any online platform. But speaking about the role of artificial intelligence in online dispute resolution, I think that is where the world is going. I recall that in 2019, I was chairman of the Nigerian Bar Association, Abuja branch then. Justice Echo of the Federal High Court, we had a session on virtual law practice, building a virtual law firm, and we had some tech guys in the house. And Justice Echo was saying that, in about 10 years or so, that we'll have virtual courts, virtual judges, virtual lawyers, robot lawyers, and he said that, I think, sometime in October. And of course, 2020 was the year of COVID. And by mid-2020, we were already having instances of virtual proceedings, the proceedings going on virtually. And, I said to myself that Justice Echo was predicting the future. We just didn't know how close the future was, until COVID happened. So I would say that there's machine learning is a huge area, and machine governance in that space is also very big. But there's a lot of learning to be had, and I see a situation where for some simple disputes, you can actually have AI provide or resolve some simple disputes. For example, situations where somebody paid for a product. This is in ordinary mediation now. Someone paid for a product, the product was not delivered, or the service was not rendered. In that case, there was no transaction, and so money should be refunded and so on and so on. So in those simple transactions, I can see there are instances where we actually have AI, resolving the disputes. But if the question is, how do we now hold the AI liable? I don't know if you hold your mediator liable, in a mediation session, or if you hold a judge liable. It's like holding a judge liable in litigation. That's why I say I'm not sure the question may be properly formed. But I think I've tried to speak to how AI can play out, or how AI can help in ODR. Is that okay?
Yes, sir. Thank you very much, sir. So now we've come to the end of today's meeting, and I want to appreciate our mentors present here with us today, Mr. Folarin Aluko. Thank you very much, sir. Your contributions and comments have been very enlightening, and I'm sure that the mentees here have learned something. I want to say thank you to Mrs. Juliana. Thank you, Ma, for this beautiful program. And thank you for all the mentees present here today. Thank you all for attending. So we would like to end today's session, and then please don't forget the other sessions next week. Please be present. Thank you all. And I've been your moderator for today, Kointola Adu. Thank you. Bye.
Thank you, everyone. Have a lovely weekend. Thank you, Mr. Folarin. Thank you, Hussein. Thank you, Oyinkansola. Thank you so much for beautifully moderating today. Thank you. So I wish everyone an amazing weekend. Thank you, Hussein. Please be expecting your question, your presentation topics and everything for next week. Take care of yourselves, everyone. Bye.
Thank you, Ma. Thank you, Ma. Bye.
Bye.
Thank you, Ma.
Bye.